When the dust settles after a catastrophic workplace accident, a terrifying question usually echoes in the mind of the safety professional on site. Am I going to prison for this? Welcome to Am I Liable? Today, we are breaking down the specific levels of personal liability for safety officers and the procedural steps required to defend your professional decisions. Keep in mind, this overview is for educational purposes, not formal legal advice. By default, regulatory bodies like OSHA aim their citations and fines at the corporate entity. A corporation is legally designed to absorb ordinary liability and shield its employees from financial ruin. But there is a specific exception to this rule. If a safety officer knowingly ignores a life-threatening hazard, that corporate shield is pierced. The individual is suddenly exposed to direct personal prosecution. While your employer might write the check for a standard fine, your personal freedom and financial survival depend entirely on the specific decisions you made in the weeks and months leading up to the disaster. When investigators arrive, they categorize human failure into different degrees of fault. At the baseline, you have ordinary negligence. Ordinary negligence is an honest mistake. It is missing a single line item on a massive monthly inspection checklist. In these cases, your company's indemnity agreement typically covers the fallout. Next is gross negligence, or willful misconduct. This is a conscious disregard for human safety. If workers repeatedly warn you about a bypassed machine guard and you ignore them to keep the production line moving, then you have crossed into gross negligence. For senior safety leadership, the legal threat escalates to the Responsible Corporate Officer Doctrine, also known as the Park Doctrine. Under this doctrine, the government does not need to prove you intended to break the law. If you held the authority to prevent a violation and failed to act, you can be individually convicted. You cannot claim ignorance by adopting a see no evil policy. Courts treat willful blindness and the intentional avoidance of the truth as absolute proof of knowledge. Sticking your head in the sand offers zero legal immunity. It is the exact trigger that activates the highest level of personal criminal liability. To understand how a court measures your actions, we have to look at the theoretical foundation of your job, the duty of care. This is your obligation to protect others from foreseeable harm. Courts apply the reasonable person standard. Did you act the way a similarly qualified peer would under the exact same circumstances? This shifts based on authority. A consultant carries different exposure than a director. Greater power brings higher legal expectations. Your liability isn't limited to what you actually knew. It includes what you should have known. The diligence requirement mandates that you actively inspect, audit, and monitor your site. If you fail this diligence requirement and turn a blind eye to systemic safety failures, the law effectively treats you as an accomplice to those hazards. The legal system does not demand an accident-free utopia. It demands an active, vigilant professional who hunts for hazards and applies standard industry expertise to correct them. In modern safety compliance, there is one absolute rule that serves as your primary defense. If it isn't written down, it didn't happen. A verbal recommendation is incredibly dangerous. Identifying a hazard and simply telling someone to fix it leaves you completely exposed. Once an accident happens, your undocumented warning practically ceases to exist. Your defense is the escalation flowchart. Generate a formal written report and move it up the chain of command to the person holding the budget. If management refuses to fund the fix, you've successfully transferred the legal burden away from yourself onto the executives. This paper trail must be objective, factual, and emotionless. Document the specific code violation and the recommended repair. Leave out speculation, workplace politics, or blame. But beware of the one uninsurable trap that guarantees a personal prosecution: falsifying records. If you forge a signature or alter a report to protect the company, you strip away your corporate indemnity and face that fraud charge alone. Meticulous, objective, and written escalation is the only proven legal mechanism that shields you individually and forces the corporation to own its operational risks. The defensive playbook relies on 3 pillars: inspect thoroughly, document objectively, and escalate in writing. By embedding these steps into your daily routine, you take a terrifying legal threat and transform it into a highly manageable administrative process. Document your actions, escalate hazards properly, and act like a reasonable safety professional. That is the best protection you have if an accident ever occurs on your site. If you want to learn more about OSHA compliance, legal protection for safety officers, and building stronger safety programs, subscribe to the HSE Study YouTube channel.